James Meredith's battle to enter the University of Mississippi. Governor George Wallace blocking the doors of the University of Alabama. The National Guard escorting children to school in Little Rock. These are unforgettable moments, images of well-known soldiers in the struggle for civil rights in America, a struggle for equal opportunity that began at the schoolhouse door. This is the story surrounding a lesser-known foot soldier in that struggle, quiet, unassuming Horace Ward and the changes he provoked. Fundamental changes in the law that dismantled segregation in the colleges and universities of the Confederate Deep South. Changes not won on picket lines or with boycotts, yet changes that set the stage for equal opportunity and justice for all in Georgia, the South, and ultimately the nation. Foot soldier for equal justice. Like the rest of the South and much of the nation, prior to the 1960s, tradition and law in Georgia dictated that whites and blacks could not mix. Segregation was the practice in most activities from cradle to grave, with special emphasis on classroom and access to higher education. Separate but equal was codified in Jim Crow laws and regulations, based on the United States Supreme Court ruling in the 1896 Plessy v. Ferguson case. That was the way of life in much of the nation until the mid-1930s, when the National Association for the Advancement of Colored People began a systematic challenge to the status quo. The NAACP formed a legal team to challenge separate but equal in the courts to end segregation, beginning in the classroom. In the 1930s, the legal defense team was led by Howard University law professor Charles Hamilton Houston. Assisting Houston was his star Howard University pupil, future Supreme Court Justice Thurgood Marshall.
I remember my freshman year at Howard Law School when Thurgood Marshall came to speak. And I can hear Thurgood now saying, "This is Charlie Houston's law school." Because it was Charlie Houston who fashioned the theory of using the 13th, 14th Amendment, the Equal Protection Clause, which was the basis for all of the civil rights legislation.
Houston, Marshall, and the defense team refined their strategy by filing cases against southern and border state law schools, schools that use various strategies to discourage black applicants.
Thurgood Marshall's first case, Maryland was his home state, and he had been denied admission to the University of Maryland. And they brought that suit and gained the admission of Donald Murray to the University of Maryland Law School. The Supreme Court of Maryland just brought their argument that if the state didn't have a separate law school for blacks, they had to admit this black student to the only law school that they had.
2 years later, the team confronted the all-white University of Missouri for proposing to use public money to pay for Lloyd Gaines to attend law school out of the state.
Missouri had offered Gaines an out-of-state scholarship, which was a program adopted by all the southern states at that time to take care of the problem of not having set up a separate graduate or professional school for black students. Of course, Gaines refused that and brought suit. When it got to the Supreme Court simply said that the state could not meet its obligation under the 14th Amendment by sending its black students out of the state. They did not go further and order the admission of Gaines to the only law school that existed. And they would not, of course, hold segregation unconstitutional.
The legal team was quiet during World War II as Americans united, black and white, to fight fascism.
Moreover, there was a feeling that blacks, like whites, had to devote all of their effort, all of their support, rather, to the war effort and to, just standing up for the country. However, the NAACP did pursue its policy of trying to eliminate segregation in the armed forces.
Returning black veterans had put their lives on the line and contributed to the Allies' victory. This emboldened them to fight segregation more intensely. Truman's 1948 executive order eliminating discrimination in the armed forces was a direct result of the attitude change. The new momentum also emboldened the NAACP Legal Defense Team to revise its legal strategy.
In 1946, when I joined the staff, there was a meeting of lawyers who were working for the NAACP, volunteer and staff, and the board, and it was decided that from now on, well, from then on, I should say, any suit which was brought would make a frontal attack on segregation per se. So the first case that I worked on was a sweat case against the University of Texas.
The University of Texas was taken to court when officials created a separate law school for black student Herman Sweat in the basement of the state law school in Austin.
Two other cases arose in Oklahoma. The suit by Ada Lois Sippuel against the University of Oklahoma for admission to its law school, and a suit by Professor McLaurin for admission to its Graduate School of Education.
Ada Lois Sippuel was roped off in a makeshift law school, and Oklahoma University officials made G.W. McLaurin sit in a broom closet off the main classroom. The Sooner State was challenged. The Supreme Court rulings against the universities in Texas and Oklahoma left segregationists clamoring for other ways to disobey the court order, to continue the educational apartheid. Born and raised in small-town LaGrange, Georgia, Horace Ward was the only child of a domestic worker and a father he never knew. Ward didn't start school until he was 9, yet was an outstanding student who preferred reading over recess. He even skipped 5th grade. He remembers that there were adults around LaGrange who saw a bright future for him.
They were mostly people down in LaGrange, such as teachers and preachers. In terms of actual people, I would say C.E. Warner, who was principal of the high school, and Reverend Fail Hale, who was a local minister. Those were people who encouraged me to stay in the school and to attend college, and some of them recommended that I might consider becoming a lawyer.
His interest included more than just textbooks.
Somehow we developed an interest in music, some of the boys in the community. So we came to Atlanta, bought instruments, and we hired a teacher, a local guy in the community who could play several instruments. And in that way, we developed a local band, and I did play the alto saxophone in the Morehouse band.
Valedictorian of his senior class at East Depot High School in LaGrange, in 1946, he joined other black men seeking to further their education and entered Morehouse College in Atlanta. The tradition of becoming a Morehouse man prepared Ward and his classmates to assume leadership roles and uplift their communities.
At the time that I was there, Dr. Benjamin Mays was president, and Dr. Mays was kind of a no-nonsense president, and we were not necessarily all the time no nonsense, but he made us toe the line, and we grew up at Morehouse. The boys who went to Morehouse came out as men who understood their roles in society and what they had to do, and they were serious about those roles. So
Morehouse educators like Mays and Robert Brisbane, one of Ward's principal advisors, imparted a sense of social responsibility in the context of the burgeoning civil rights movement. Despite their sense of mission and relative isolation within the Morehouse walls, Jim Crow was a reality outside Morehouse,
there was a theater in Atlanta called the Fox Theater, where black folks could attend, but they had to go around the back, go up the steps, and to see the movie. White people, of course, went into the front. And we went to what they called the Buzzard Roost, way up at the top. And I used to go to the Fox Theater. I went to chapel one morning, right after I entered Morehouse, my freshman year. And Dr. Mays said to the student body that Morehouse men can never afford to pay for segregation. That Morehouse men must understand that they have a commitment that they must make. And to make this commitment, they must make it void of any system which rendigates you as being inferior. I sat there and thought that Dr. Mays saw me come out of the Fox Theater when he made this statement. But from that day forward, I never again went to a segregated theater.
In September of 1950, armed with a bachelor's degree from Morehouse and a master's degree from Atlanta University, Ward answered his calling and sought admission to the University of Georgia Law School.
I became interested in attending the University of Georgia while I was attending Morehouse College, and I already had decided to go to law school, and I decided might as well attend school in the state.
This was a time when black lawyers were a rarity in Georgia, and black law students were a novelty at law schools where they were admitted. Georgia's law school was not one of those.
Well, I had originally, back down in LaGrange, come to at least the thought that I would attend law school and become a lawyer. And that was largely from the efforts of these people, teachers and preachers and other people in the community. However, I had read about the lawyer, a black lawyer in the state of Georgia at that time, Austin Thomas Walden, commonly referred to as A.T. Walden, and he was one of the first black persons to successfully practice law in Georgia. There had been some publicity about him and how he had made it, having been a lawyer in Georgia since 1911. So that gave me some thought that that a black person at that time could pursue the law.
The charismatic Walden, who graduated from the University of Michigan Law School, was a role model of singular distinction, whose influence reached many other young men like Vernon Jordan.
Sort of the reason I'm sitting here in this law firm and this corner office as a senior partner is not unrelated to the incredible influence that A.T. Walden, who was the first black lawyer I ever saw. He was so impressive, and I liked the way he talked. I liked the way he stood straight and tall. I liked the way he articulated his views, and I can hear him saying, as a kid, in that choir, I can hear him saying about segregation. I'll be dead, glad when you're dead, you rascal, you.
Before Ward submitted his application for law school at the University of Georgia, he revealed his intentions to Dr. William Boyd, chairman of the political science department at Atlanta University. Boyd had a profound influence on Ward.
I had already secured an application sometime before that time, so I went to see Dr. Boyd and told him that in the summer of 1950 that I was interested in studying law and I might very well file an application to the University of Georgia. And he said, if you make up your mind to do so, come to see me and I will assist you and give you all the support that I can.
Boyd started his civil rights advocacy as a young college student. He had a reputation as a radical thinker and a maverick professor, using current events as his textbook.
He had an unorthodox way of teaching. He would bring the New York Times to class and require us to purchase it. And he would teach from the New York Times. But he was committed to desegregation as state head of the NAACP.
Boyd used WERD, Atlanta's first black-owned radio station, as a platform to exhort the black community.
Above analysis points to but one conclusion. Segregation is doomed. It is no longer a question of whether, but of how soon. Politicians in Georgia in Texas, Mississippi, Alabama, South Carolina, Virginia, North Carolina, and the other southern states may, in the words of a famous Georgia politician, kick, snort, and paw, and say what will not happen. But even they cannot obliterate the psychological effects of knowing that an era is dying.
Ward's application to the university fit into Boyd's plans as president of the state conference of the NAACP.
Bill wanted to get a student to apply to the University of Georgia. And he first interviewed Martin Luther King, Jr. He was at Morehouse at the time, Martin Luther was. But Martin Luther, of course, was interested in the ministry. He wasn't interested in law. So then he talked to Ward, who was his student. And he happened to be a very good applicant and had all the credentials for going into the university, but nope, they turned him down.
The application Ward submitted was ignored. The Board of Regents instead offered the traditional out-of-state aid scholarship, which Ward refused.
So I went to Dr. Boyd, and Dr. Boyd brought Attorney Walden into the case, and thereafter had two advisors, Boyd and Walden.
Walden called upon Thurgood Marshall and the Legal Defense Fund for expertise. The team eventually included Constance Baker Motley, Robert Carter, and Donald Hollowell. Hollowell, then a young Atlanta attorney, was developing a reputation for his civil rights expertise, a reputation that would grow in stature over the next 2 decades. In a visceral response to Ward's refusal to concede, the Board of Regents, led by board member and Democratic power broker Roy Harris, abruptly changed the admission rules.
I filed an application in September 1950 asking to be admitted in June 1951. That's a long time, you see. And during the course of that time, it is my thought, and I think the records will bear it out, that the rules were changed. And what was put in place was an elaborate administrative appeal procedure.
My recollection is that they threw in his way every possible administrative obstacle to keeping him from getting into the school, from getting into the university. There were all kinds of applications that had to be filled, and every T had to be crossed, every I dotted. An applicant, as I recall, who was trying to get into the University of Georgia had to have letters from alumni supporting him. He had to furnish a picture so that they could make certain he was white. There were all kinds of subterfuges and obstacles thrown up. Most of this was done at the direction of the office of the governor and Roy Harris.
They decided to require Ward, and presumably all prospective law school students, to secure recommendations from 2 alumni and a Superior Court judge from their home district.
I just thought it was a terrible thing. After all, the alumni, they weren't interested in getting any blacks into the university. And how are you going to find somebody who would sign an application and say, yes, this man is of good character?
Generally, when new requirements are put in, they have a purpose, and at that time I think the test requirements were put in to keep black students from being admitted. I don't think there's any question about that, and I don't think anybody now would deny that that was why they were put in.
Had Ward or any other black applicants managed to get the necessary references, the university system was prepared with yet another obstacle for Horace: a highly subjective battery of examinations, including a legal aptitude test.
Some of the tests that blacks were required to pass, the Chief Justice of the United States Supreme Court today could not pass those tests. The test was not set up to see whether or not he was qualified for admission. The test was set up to keep him out. Whatever subterfuge, if he'd scored 100 on the test, it didn't make any difference. They would have said he signed his name incorrectly.
In rejecting Ward, state officials, led by then-Governor Herman Talmadge, believed they were protecting a cherished way of life, but wound up imprisoned by their own xenophobia.
I grew up with blacks on the farm. We went fishing together, swimming in the nude. Some of the best friends I had were blacks. And then when it got time to where I attended school, our paths were divergent. You see, we had several hundred years of segregation. And it was the mores and custom, not only of the people, but it was written in the Constitution and laws. And any political figure that dared to defy that wouldn't have carried a county in the state. Any Southern leader would have had different views from mine, would have been run out of office the same day.
That prejudice came with a high price. It was a social and moral battle waged at all levels of state government. In a 1951 appropriations bill, the legislature resolved to cut funds to the university if Ward or any other black were admitted.
The strategy was, no, you can't go to school here. We'll just close the university down. Well, I don't think anybody thought that was very realistic. I don't know who thought that was anything other than just a stalling mechanism.
While Talmadge called the plays from the Capitol in Atlanta, University Regent Roy Harris ran a defense to demoralize the opposition. Harris galvanized public opinion against desegregation on the front pages of his newspaper, the Augusta Courier.
The Augusta Courier, of course, well, that was I thought of it in those days as simply a personal mouthpiece for Roy Harris. And that was where he said made the very extreme statements that he did about us and about desegregation of the university system and so forth. But I didn't think of the Augusta Courier as a newspaper. I thought of it in those days as political polemics. It was Roy Harris's mouthpiece, I thought.
On campus, cracks in the wall of segregation began to appear. The Red and Black, the university's student newspaper, raised its voice in support of Horace Ward.
We did publish an editorial called Created Equal, which Bill Shipp wrote. It said simply, there isn't any reason why we deny this large segment of our society the privilege of coming to the University of Georgia. It didn't mince any words.
The Red and Black wrote a series of editorials, and I wrote a series of columns criticizing the administration of Governor Herman Talmadge for moving to thwart Horace Ward, a black man, from entering the law school at the university.
The Red and Black's editors discovered there were costly consequences to their stand.
In the wake of all this, the Board of Control of the Red and Black told us that any prejudicial material, controversial material, something like that, I've forgotten exactly what word they used, would have to be submitted to them in the future for approval.
The school, John Drury, who was then the dean of the School of Journalism, and Dr. O.C. Adderholt, who was then the president, decided it was in the best interest of the university that a faculty advisor be taken over to review all Red and Black editorials and all Red and Black editorial content before they were printed, apparently to stop any further drive, any further editorial efforts at gaining Horace Ward's entry into the law school.
Another budding journalist, Gene Britton, recalls the reaction to the Red and Black at the Board of Regents.
Bill Shipp and I went to Atlanta to cover a meeting of the State Board of Regents. And a very prominent member of the board was Roy Harris of Augusta. Mr. Harris was, I'm not sure whether Roy Harris was created by the Talmadge political machine or whether Mr. Harris contributed significantly to the creation of the Talmadge machine, but he was certainly very prominent and in Georgia politics at the time. He saw us there and had a copy of the Red and Black and the editorial, and he approached us and was very critical of the Red and Black and suggested that maybe rather than doing sissy activities like writing for a school paper, we ought to be out playing football or doing something really macho.
The Red and Black student editors resigned after the challenge to their First Amendment rights.
after a good deal of soul searching and agonizing and wanting to stay and trying to find a way to stay and with a clear conscience, I just could not do it. I finally just could not do it. And I remember Gene Britton and I went to a prayer service at the Methodist Church and prayed about it. We talked and talked and talked, and finally he went to his dorm and I went to my sorority house, and the next morning we got together and discovered we'd made the same decision. So we went ahead with the issue of the Red and Black that we were putting out and resigned.
Support for the student journalists came from the Atlanta Constitution's Ralph McGill, the Gainesville, Georgia Times, from newspapers and hundreds of letters from across the nation.
What I do remember and what I was impressed by was the national attention that the story got, and the fact that we got a lot of editorial support from newspapers all over the country, and I think from some national magazines as well.
One faculty member, law school professor James Lenore, did support the students in Ward's application. He contended that changing the admissions process to require references and subjective tests was a form of subterfuge not enforced with white applicants. Morally outraged, Lenore felt compelled to resign and moved his family out of state. As the free speech debate raged on campus and Ward's application headed toward court, Horace hadn't wasted his time.
I was hired in late September or maybe October of 1950 to be an instructor of social science at Arkansas A&M College in Pine Bluff. And I worked that 1 year out there while my application was pending, and came back to Atlanta during the summer. And in September of 1951, I was hired by Dr. Trenum to become an instructor of social science and history at Alabama State College in Montgomery, particularly at their Mobile branch.
Mobile is where he met his future wife, a member of a prominent black family. Then in 1953, one of those amazing coincidences of the civil rights movement unfolded. Just as Ward's case was ready for trial in October, it became moot. Ward, originally classified ineligible because of a hernia, underwent corrective surgery and was reclassified as fit for duty and drafted into the Army, exactly 30 days before his court date. Ward didn't find the timing odd.
There had been some notion that I would be drafted. I didn't know when. I think it was coincidental.
It didn't seem so coincidental to Priscilla Davis and others.
I think the fact that Mr. Ward was drafted in such a timely manner when he was his case was about to come into court was a bit much of a coincidence. I think perhaps goes beyond coincidence, and may in fact have been another of those hurdles that we talked about that officials would find to throw up.
You can be sure that we wondered whether or not it was a purely coincidental thing, and our better judgment told us that it was not.
Ward shipped out and eventually served in Korea, and the university didn't have to face a court fight over desegregating. Not yet.
So all of these cases that had been filed at the graduate or professional school level were on the back burner, so to speak.
Put on the back burner by the NAACP legal team until the Supreme Court ordered a special session to hear the pivotal desegregation lawsuit of the century, Brown versus Topeka School Board.
Once the Supreme Court outlawed segregation in education per se, in the Brown case in 1954, we went full speed ahead with respect to these pending cases at the graduate and professional school level. And one of the cases that had been pending since 1952 was a case in which Horace Ward sought admission to the University of Georgia Law School.
Ward completed his tour of duty and revived his case against the University of Georgia and the Board of Regents.
The case had been filed by Thurgood Marshall and Constant Motley and Mr. Walden and Robert Carter of the NAACP. I got into the case late and became the chief local counsel. I came in about the time when they were beginning to have difficulty after he had been rejected, and that it had to then go from there on to the President's Committee and on to the Chancellor and then to the Board of Regents.
Throughout Ward's ordeal, William Boyd had helped finance Horace's efforts to get admitted to Georgia.
I would say the primary sources of the funds, as I understood it, came from Dr. William Madison Boyd serving as a president of the State Conference of Branches of the NAACP, becoming a circuit rider, so to speak.
The momentum of the case took a serious blow when William Boyd took ill.
He had had headaches, and we couldn't understand. He kept changing his glasses, thinking there was something wrong with his glasses. And that's when they diagnosed him as having leukemia.
William Boyd died at age 39, but his words rang on.
If, however, Negroes are willing to fight through the courts of law without giving quarter to any group of person who would compromise their quest for first-class citizenship, then Negroes can look forward to the culmination of the celebration of the 100th anniversary of their emancipation in 1963 as being the banner year in which they might, in essence, be free as American citizens.
Back in the courtroom, Ward dropped a bombshell of his own.
I was already attending Northwestern when I went to trial, but had not told anyone. And I was asked on the stand, well, what are you doing today, Mr. Ward? And where are you living? I said, I'm living in Chicago temporarily. And I said, what you doing up there? I said, I'm attending the Northwestern University School of Law, which indicated that I must have been serious.
Which was contrary to the state's argument that Ward was a paid stooge of the NAACP.
I wasn't drafted for this job, for the job to integrate the University of Georgia. I was a walk-on player. The effort was to show that I didn't want to study the law, but I was a tool of the NAACP, being paid by the NAACP to file this case just to get rid of segregation at the University of Georgia and in the Georgia system. I hadn't been paid by anybody, and that effort was carried on down through the trial. And a statement was made that they didn't consider that I was a bona fide student. But I was, kind of a foot soldier for the integration efforts. But I had always planned to study law, so I was disappointed.
The reasoning of the university regents was that Horace and other blacks just weren't qualified.
When they finally went to law school, and almost all the rest of these young men who were denied admission just didn't, backed up and reapplied to Harvard, Yale, Amherst, or wherever they wanted to go, and got through without any problems at all.
I think it was an outrage. And as a matter of fact, the more I talk about this with you, the more furious I get. I remember how angry we were back there, that the state of Georgia would tell another human being, because of the color of his skin, that he didn't have the right attitude, that he did not possess certain character qualities that allowed him. That is an outrage. That in the last half of the 20th century, we were still practicing that kind of segregation in this state.
The forces of segregation declared victory in Judge Hooper's courtroom as Ward boarded his train for Chicago and Northwestern University. Undeterred by the judicial setback, Ward returned to Northwestern University Law School to complete his law degree, with every intention of returning to Georgia to practice while the struggle in the South continued. Only a few months later, Donald Hollowell was back in federal court, arguing a parallel case. It involved the Georgia State Business College, now Georgia State University. 5 young, ambitious blacks, Barbara Hunt, Irish Welch, Russell Roberts, Marion McDaniel, and Myra Holland, started on the same stony road that Horace Ward had traveled. Ludicrous admission requirements designed to deny Ward his 14th Amendment rights of equal protection under the law would also become stumbling blocks for Georgia State applicant Myra Holland.
I graduated from Boggs Academy in 1951, and I was a valedictorian of my class. Subsequently, of course, I came back home to Atlanta, and I had wanted to go on to college, but of course I didn't. My father and my mother separated the same year that I graduated from high school. So I went to work that fall instead of going to college. I learned about the school here at the corner of Cortlandt and Gilmer Street. And one day a group of us, when we got off, and we also learned that you could attend school at night and work in the daytime. So that just suited us just fine, plus it was close. And so we came over to pick up some applications, a group of us from work. It was close. It was a state school, so therefore it would definitely have been cheaper than Spelman or Clark or any of the private schools in town. And I just thought it was a good place to get an education.
That is when the attack of minutia began.
It stated that our applications did not have the signature of the clerk of the Superior Court. And of course, he refused to sign them. And the reason being, he said that they were not, that's not the way they were handled. But his other contention was that he did not personally know us, so he could not vouch for our character.
Holland and her friends were supported by community activists like Atlanta Life Insurance executive Jesse Hill.
We felt that we knew the kind of sophisticated barriers that were put up, all kinds of excuses from even giving you an application to file, and once you get the applications, creating other bureaucratic barriers.
Holland and her colleagues found support in the black community and in her workplace.
Physicians and dentists, we found that they were very supportive and eager to do what they could. Now, I'm not saying that other black businesses were not helpful. They were. I would have to say, though, after Atlanta Life, Atlanta black real estate brokers were very key and very strong and supportive.
It was a combined effort, and these people were really involved in something. This was almost revolutionary, but it was essentially an effort in those days of the black middle class. We'll get more of the black masses involved when King comes along, and we can mobilize the urban centers. But at that time in the 50s, this was largely an activity of the black professionals. Essentially, as he put it, black faculty, but also your doctors and dentists and so forth and so on. And alumni. And alumni, that's right.
With the NAACP involved, the state mounted a familiar defense inside and outside the courtroom. Roy Harris again played the race card as spokesman for the forces of segregation.
Well, the popular Roy Harris, the popular notion of who Roy Harris is or was akin to a caricature with horns and a tail. He was a segregationist. There is no doubt about it. He was a segregationist.
I think Georgia politics in the early days was based on race. And I think that if you were going to get elected, the person who could holler nigger the loudest and who said that he was going to keep down black folks in this state was the one who maintained their political positions. And I think that the facts will bear that out. I think Roy Harris was a disciple of that same philosophy and attitude that as long as we convince white folks that we're going to keep black folks down, then we'll get elected in the city.
Harris, a diehard segregationist, resisted the changing political winds. But like any experienced sailor, he would eventually choose a more expedient, practical course.
He wanted to try to soften that segregationist image in his winding down days, his sunset days, and say, I want people to really believe that I wasn't the bad devil that many of them thought I was, so I'm going to take my risks and chances with Ed McIntyre and go down in history as not being just purely a segregationist, but being one who could come and support and advise an African-American who's the first black mayor of the city of Augusta.
A new player was presiding Judge Boyd Sloan. While the state immediately put Holland and the other students on the defensive, Sloan was a joker in the segregationist deck.
Nobody seemed to know his background. Nobody seemed to know that he was, I guess, what they call a liberal. And he ruled with us. And he enjoined enforcement of the policy. He enjoined the requirement that they have 2 alumni, and all the other silly things that they had brought forward so that their applications could be then considered on the merits.
Ironically, this ruling, albeit late, vindicated Horace Ward's suit against the University of Georgia. Judge Sloan found that the alumni reference requirements were obstacles aimed at black applicants, and that out-of-state aid scholarships did not provide equal protection under the 14th Amendment. The victory fell short, however, when Georgia State was allowed to reject Holland and one other plaintiff on character grounds.
What they would do is to investigate the plaintiff, whoever that plaintiff was, male or female, from the day they were born.
I suppose if they could find any way to deny you, they would find it in your personal background as opposed to find it in your academic background, generally. Most people, they have done some things that they are not necessarily that proud of, even though it was not illegal or not against the law. Maybe that's why I wasn't in too much of a mood to celebrate, because despite the fact that we won, it was obvious that we had not won him over.
Though they lost one round, Georgia officials in the legislature immediately erected still another devious barrier. They passed a law setting an age limit of 21 for incoming freshmen in the public college system. It just so happened that the black applicants were all over 21.
I think I was around 26 and Ms. Hunt was about the same age. That sends an antenna up to anybody, well, what's wrong with them? But anyway, we didn't let it bother us.
The lessons learned from the Ward and the Georgia State case created a roadmap for opponents of segregation.
I just think that the case of Horace Ward and the Georgia State cases laid the foundation, a good solid foundation. They were very instructive. They gave us a lot of gave us a lot of do's and don'ts as far as going forward. They were vital.
The university in Athens, while still segregated, again became ground zero for a renewed assault on its all-white status.
And we felt that the University of Georgia is the heart of the university system. Georgia State, Georgia Tech, the medical school, they were important. We decided that to get enough students, and it's just like we want to get a success case, and we thought we'd go with the best team.
That team of litigators and scholars included veterans and fresh recruits.
We had all the good ingredients. We had Hollowell, we had Constance Motley, we had the Legal Defense Fund. We had 2 excellent students who were ready and committed and determined.
The daughter of an Army chaplain and a career woman, Charlene Hunter was an aspiring journalist. Hamilton Holmes was the son of a family long active in the civil rights effort. He wanted to become a doctor, aspirations which attracted attention.
Around January or February of my senior year, this would have been 1959. A group of Atlantans, Jesse Hill, gosh, I can't think of everybody's name, Hollowell. My dad was in the group, and they canvassed the city, and they decided that I was the top male graduate and Charlene was the top female graduate. Just so happened that we both went to Turner High, and they asked us.
Holmes and Hunter, like generations of Georgians before them, knew that the most coveted path to success in the state led through the University of Georgia.
So with the Henry Grady School of Journalism over at University, which is considered to be one of the best schools in the country, I mean, that was a natural for Charlene. And with Georgia's Liberal Arts College, it was better for me. So we said, we want to go to Athens.
The university replayed the game and rejected their applications.
They told us that because of no dormitory space, they did not say because we were black, they were not accepting us. We said, fine, keep our application on file for the winter quarter and the spring quarter. So winter quarter, they told us, we still don't have any space. Spring quarter, we don't have any space. They did not accept us for the fall of our sophomore year, and that's when we decided we would sue.
By now, the legal team representing Holmes and Hunter were quite familiar with this particular fight.
I think Donald Hollowell was probably the leading civil rights lawyer in the South, and he happened to be in Atlanta. So I know he was recruited first. And then they brought down Connie Motley from New York City. Hollowell had Horace Ward, who had been the first black to apply to the university as a law student back in the early 50s.
Yes. After 3 years in Chicago earning a law degree at Northwestern, Horace Ward was back.
So I joined Donald L. Hollowell's office in 1960. Of course, one effect it was I was already known in Georgia because of my efforts to enter the University of Georgia.
This moment in his life was one of several ironic events that would affect Ward for years to come. His first major case as a practicing attorney was practically a carbon copy of the complaint he filed against the same school a decade earlier.
Another important thing, Don Hollowell associated me on a case that was then pending. He and Constance Baker Motley were representing Charlene Hunter and Hamilton Holmes in their effort to enter the University of Georgia. They had already gone through their application process, which was somewhat similar to mine.
Hollowell's team was in place, ready to finally open the doors of Georgia's flagship educational institution to African Americans.
So the team primarily was Hollowell and Connie Motley, and then Hollowell had Horace Ward, who had been the first black to apply to the university as a law student back in the early 50s. He had Vernon Jordan, who was a young guy that had just graduated from law school.
I carried Hollowell's briefcase, I drove his car, I did his research. I studied under him. I was his law clerk, I was his intern, I was his mentee.
Resistance hardened among segregationists. Ernest Vandiver, the lieutenant governor, reached the zenith of his political career, campaigning for the governor's mansion by appealing to the fears of whites.
And I listened to him on the radio, and I said, my God, this is the first man running for governor that I've never heard use nigger and race. I said, well, maybe we overcome it in the state of Georgia. But somebody got to Vandiver.
And I saw Ernie Vandiver get up on the platform in Thompson, Georgia, and they had the high school band out there, and it was mostly white people. And he swore to that crowd that if a black student set foot in a classroom in the state of Georgia, that he himself, if no state trooper would do it, would escort that black person out of the courtroom. And the crowd cheered.
In 1958, I had served 4 years as lieutenant governor, and my campaign platform at that time was to preserve the county unit system, to preserve segregation, which we'd been brought up with all of our lives, to give the legislature independence, and to not raise taxes.
Vandiver's campaign promise of no, not one Negro would be admitted would be easier to make than to keep. But Vandiver, himself a university law school graduate, was playing political chicken. Equally determined to force Vandiver to break his promise on segregation, the ad hoc coalition achieved a remarkable degree of unity in Atlanta's black community. The Atlanta University Center, which symbolized the rigid caste system among African Americans, instead became the incubator of support for Holmes and Hunter.
There was never a separation from the university of what we were about, and it was a kind of reinforcement of what we were doing, because at that time there was this, in my judgment, unified partnership within the black community about this particular case and this particular aspect of the civil rights movement.
Atlanta is a progressive community, and the Atlanta University Center was a strong, proud community, and the heads of these institutions, the faculties were strong, well qualified. They felt that they offered high standard education, but they also supported the desegregation of the University of Georgia.
Hollowell, Ward, Motley, and Jordan representing Charlene Hunter and Hamilton Holmes. It was Holmes who became the focus of the state's attack.
I think he tried to break me, especially me, because I mean I was the main one they were going after rather than going after Charlene so much. I mean, they were going after me like this black male thing, you know.
Exactly as they had a decade before with Ward, the university system argued that Holmes and Hunter were not being discriminated against. They had simply not completed the administrative process, so were not qualified to enter the university. The parallel rose to the height of irony when Holmes took the witness stand.
I was called upon to conduct the direct examination of Hamilton Holmes. Mr. Hollowell decided that should be of some passing significance in view of the fact that Hamilton Holmes had been denied admission to the university. And the university officials had given basically the same reason as Judge Boodle would later mention in his opinion, that the reasons given for the denial of Hampton Holmes' application very similar to Horace Ward's application.
In the end, the judge found no escape from ruling in favor of Holmes and Hunter.
Judge Boodle, who I got to know and got to know me after this, he was a segregationist also. He said he was, but after hearing all the facts, he said he had to do what he thought was right, even though he didn't really want to do it.
The two young black Georgians were admitted to the University of Georgia for winter quarter classes in January 1961. They became standard bearers for desegregation of the major public universities across the South. Their accomplishment was trumpeted nationally in the media. All the while, the man whose shoulders supported Hunter and Holmes in Georgia, then James Meredith in Mississippi, and later Vivian Malone and James Hood at the University of Alabama, went quietly on his way. Horace Ward had begun this fight, and in many ways the victory was his. This was only the first part of Horace Ward's story, a story that takes him to senior status on the federal bench. And his is but one of many stories of black lawyers using the system of law to end the American apartheid.
These are unsung, not much appreciated heroes. And most people who benefited from their commitment and from their talents don't know their name, but know what they do. But they are the beneficiaries of these lawyers, black lawyers who went home from law school to make their talents as lawyers available to the ultimate aspirations of black people. Life, liberty, and the pursuit of happiness on the basis of equal opportunity. That's the American way.